Due Process, winner of 22 Regional Emmy Awards, including the 2012 and 2013 Mid-Atlantic Emmys for Outstanding Discussion Series. Due Process is a presentation of Rutgers School of Law, Newark, and the Edward J. Blaustein School of Planning and Public Policy. Studio facilities provided by the Rutgers ITV Studio, Division of Continuing Studies.
They've already decided death penalty in Alabama, an abortion case out of Texas, and a state's right to charge tax on internet sales. But with much more to come before the current term ends, from birth control coverage under Obamacare to affirmative action in higher education, presidential powers to prayer at public meetings. It's our annual Supreme Court update with our favorite court watcher, Steve Shapiro, the ACLU's court guru, on this edition of Due Process.
Major funding for Due Process provided by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding from Genova Burns and the New Jersey State Bar Foundation.
It's that time of year again. The U.S. Supreme Court back in session, making headlines as always with cases that range from revisiting affirmative action to the rules on Obamacare and coverage for contraception. I'm Raymond Brown.
And I'm Sandra King. And when we talk Supreme Court, we always try to do it with Steve Shapiro, our favorite court watcher, National Legal Director for the ACLU, and for this annual event at Due Process, less an advocate than an insider guide to the workings of the court and why they matter. So this year, let's talk about what matters. It is not as exciting a year as last.
It's a slower year, but some of us think that's okay, Sandy.
When we got together last year, we were looking forward to rulings on voting rights, same-sex marriage. They came, they were momentous. This year, we see same-sex marriage showing up again. Tell us about the Utah case. What's going on there?
Well, what's going on in Utah is a function of what went on in the Supreme Court last year. So the Supreme Court decided two cases at the end of last term in June. One was the Windsor case, in which the court said the federal government had to recognize marriages that were recognized in the state in which the couple lived. But it was not a decision that required any state to actually recognize marriage if they had not already made the decision to do so. The second case, which teed that issue up, the court ultimately never really resolved, a case called Perry versus Hollingsworth. It left gay marriage in place, in same-sex marriage in place in California, but didn't require it in any other state. And so what has happened since then is there are several dozen lawsuits that have been filed around the country to now push the issue that the Supreme Court has left unresolved, and that is, does the federal Constitution require that every state in fact recognize same-sex marriage? And Utah was one of those places where a lawsuit was brought, and a federal judge in Utah a month or so ago ruled, based on the Supreme Court's decision in the Windsor case from last term, that in fact the federal Constitution not only required the federal government to recognize marriages that had already been accepted, but it required every state to, in fact, allow same-sex couples to marry, including Utah, and he ordered Utah to permit same-sex marriages. Utah appealed that decision, and while the decision was going up on appeal, it asked the Supreme Court to block the trial judge's order from going into effect. And the Supreme Court agreed to do that. So we have a decision now that says the law in Utah banning same-sex marriage is unconstitutional, but we no longer have same-sex marriages being implemented in Utah because it's all been put on hold while the appeals go forward. So what the Supreme Court did is kind of dipped its toe back into the waters of same-sex marriage. I think what it was trying to do was just maintain an orderly process so we wouldn't be in a situation where we had a lot of marriages and weren't sure whether they were valid or invalid until the issue was finally resolved.
How big of a doctrinal leap is it from the conclusion of Windsor that effectively a state, while defining marriage, may define it to include same-sex marriages, to the Utah issue that the Equal Protection Clause and other constitutional provisions require that?
I think given the way that Justice Kennedy wrote the decision in Windsor, it actually is a very small step. And that's what Justice Scalia said in dissent, and I think he's going to be proven right. And I think what's going to happen is we're going to start to see a lot of decisions around the country, like the Utah decision, that take the next step, saying every couple, whether it's a opposite-sex couple or a same-sex couple, has the same right to marry the person they love. And the issue will get back to the Supreme Court at some point. I don't know that they will take the first case. I don't know that it's going to be next year or whether it's 2 years down the road. But I think there are very few people who doubt now that in a relatively short period of time, this issue will be beyond us. And I think we will look back and say, what was the fuss all about?
Let me ask you one Scalia-specific question. Scalia is an interesting judge in the sense that he does, in many instances, like the death penalty, demand a certain intellectual rigor, that if you're going to do this sometimes, you must do it all the time. Do you think it's likely that based on Windsor and regarding it as precedent, he would go the other way if the issue were squarely presented about whether same-sex marriage must be permitted? Or do you think he's going to continue in a dissent?
I think he will continue in dissent. I will be very surprised if we ever get to a point where Justice Scalia says the federal Constitution requires same-sex marriage. But I think he's going to be a dissenter. I don't think that's where the majority of the court is going to be. And it's just a question of when they reach the comfort level that they are prepared to say that. And the more states that fall into line, the easier it becomes for them to do it.
Here in New Jersey, where we had a state Supreme Court decision since 2006 that said you have to allow same-sex couples to have equal rights and privileges, but you don't have to call it marriage. DOMA then comes in, makes all the difference. Same-sex marriage now legal and very active in New Jersey.
Right, because once DOMA was declared unconstitutional, it was clear that civil unions were not the same as marriage because they didn't bring with them the federal benefits that marriage provided after the Supreme Court's decision in Windsor. But we're at a sort of interesting historical moment now because we have same-sex marriage in almost every state in the country, maybe every state in the country, that doesn't have a state constitutional amendment that prohibits it. So it is very difficult to get same-sex marriage in those remaining states through the political process. All those states, I think, are going to require litigation unless they amend their state constitution, and that's often a long and arduous process. And I don't think the U.S. Supreme Court is going to make us march through 31 more states. There's going to be a point where they say a critical mass has been reached and we're ready now to sort of end this for the entire country. And I really do not believe we're going to have to wait very long to get to that point.
In terms of journalism and law, frequently you see newspapers jumping on the idea of a stay of an order as an indication of how the case is going to turn out on the merits. That seems to me to sometimes be potentially very tricky. You had the judge in the NSA case stay his order. There are other cases in the channel to the Supreme Court where stays have been granted or not granted. Is it dangerous for especially people in the media to be speculating that where there's a stay of the order pending further action, that you can decide what the answer is going to be on the merits from that?
I think sometimes it's more of a clue than other times. But if you take something like the NSA cases, I think that everybody involved in it recognizes that this is a momentous issue on both sides of the equation, the national security issue on one side of the equation, the privacy issue on the other side of the equation, and that it ought not to be finally resolved by a trial judge at the first level of the federal judicial system. So they issue their opinion and then say, but we're going to hold off until some higher judges get to rule on this. In the Utah case, what happened in Utah is that the trial judge struck down the law. People started to get married. The Supreme Court granted a stay. And now there's a fair amount of confusion about the status and validity of those marriages that occurred in between, right? And I think the Supreme Court just said, let's try to do this in an orderly way so we don't have people in limbo.
It's already pretty complicated because the Attorney General of the state said, you stay where you are. So if you've already begun to get benefits, you stay there. If you've just started in the pipeline. So ultimately, there's going to be a complicated task of unraveling all that unless there is ultimately an affirmance of the right or a requirement, in effect, that Utah grant.
And the United States Attorney General has weighed in and said we're going to grant federal benefits to the couples in Utah that got married in this interim period. But I think the Supreme Court was just thinking to itself, let's try to minimize that disruption to the extent that it possibly can. And I don't think that their stay order suggested at all where they are on the final issue.
On the NSA question, we've now got 3 lower courts, 2 taking one position, 1 taking the other. Everybody seems to agree that eventually this goes up. It won't happen in this term, but that eventually the question of NSA and privacy goes to the Supreme Court. Where do you see that?
Well, I think it absolutely goes to the Supreme Court unless there's a change in policy or practice. And that is possible because you have a presidential advisory commission that had been appointed by President Obama, who came in with a whole series of quite far-reaching recommendations for how the surveillance process ought to be changed. The president is scheduled to deliver a major speech in the near future in which he's going to, I suspect, embrace some of those recommendations and reject other recommendations. There are bills pending in Congress, right? So the world could look different in another 6 months, and if the rules change, then that will slow down, the whole process of Supreme Court review.
Sure, but given how strong the feelings are on both sides, can you imagine that even if some of it's diffused by the Obama administration, that the cases will, in one form or another, go forward and go up?
Here's the thing. If there is at least one court, right, at the level below the United States Supreme Court that rules against the government, then the case absolutely goes up. There is no way that the United States Supreme Court will allow any lower court to have the final say if what they're doing is invalidating what the government is doing in the national security context, right? If the government winds up winning all the cases at the next level, then I think it's less certain that the Supreme Court jumps in fact.
Okay, let me take you to another realm. Sandy has appropriately introduced you as our guru and guide, but we're going to have you wear your advocate hat and your guru hat at the same time on this one. Tell us about the Massachusetts case in which the ACLU has an interest, which involves the question of how you deal with protests outside abortion facilities.
Well, there's obviously been an issue for decades, right, about protesting outside of abortion clinics.
Happens all over the country. We see it not too far from here in New Jersey all the time.
Happens. There's hardly a clinic in the United States that performs abortions that has not had protesters outside, and often for years, and many of them are peaceful and some are not, right? And that's true for all protesters on all issues.
But even when they're peaceful, they want to approach you and engage you in conversation if you're walking in, and that's where we come to the
So what Massachusetts did was
case.
Massachusetts passed a law, and Massachusetts has a particularly unfortunate history of violence at abortion clinics, and there have been abortion providers in Massachusetts who have been murdered. So in part in response to that history, and in part in response just to a history of protests at abortion clinics, Massachusetts adopted a law that said nobody can protest closer than 35 feet to the entrance of any abortion clinic.
To the entrance.
To the entrance. It created a buffer zone.
Not to the people walking in.
To the entrance, to the door, and there is literally a line that is chalk line that is drawn on the sidewalk, and if you're a protester, stay on one side of the line, and the moment that a patient or an employee or staff at the clinic crosses the line, they're in a no protest zone and they get to enter the clinic. And that law was challenged by protesters who saw it as a violation of the First Amendment rights, and defended by the state and defended by many of the abortion providers themselves as a really relatively modest endeavor by the state to ensure that women can get in and out of the abortion clinic safely and without intimidation or harassment.
The granular question of who stands where is initially a police or a regulatory function of the state. Correct. But then there can be constitutional implications.
Correct. There is no First Amendment rule that says you get to stand here as opposed to there. So in the first instance here, Massachusetts happen to have passed a law. What happens every day day of the week in every city in the country is in places where there are no law. If you show up at an office building and you want to picket, it's a labor picket, the police will put up barriers and they'll say stand on one side of the barrier and not on the other side of the barrier. So you're always told, in essence, where you can protest. But there is a very important First Amendment principle, which is you have a right to reach your target audience, right? And that right to reach your target audience includes, we believe, the ACLU believes, more than the right simply to hold up a sign, more than the right to shout at people across a distance. It includes the right to approach people, hand them a leaflet, and try to engage them in conversation.
So now the question becomes, as an advocate, some of your friends and allies even are saying, look, you've generally been on the legal side of pro-choice issues. How do you wind up on this other side when the question isn't one of banning protesters, but the question of how far away they can stand, especially since some people say, I'm intimidated by having people come so close or raise their voice?
And you want them close enough to be able to hand a leaflet.
Correct.
That's
Right.
close. That's in your face when you're going in to an abortion clinic, presumably for a very sensitive and private.
Close enough to hand the leaflet, but we said you don't have to be able to do that within 35 feet of the door. So we actually submitted a brief in this case that in the nomenclature of the Supreme Court was called a brief in support of neither side. And that's in part because we care deeply about both rights here. We care about the right of women to access abortion. We care about the right of people to be able to peacefully protest on the streets, right? And so what we said is you can't make a universal judgment about whether 35 feet is the right distance or the wrong distance. It depends very much about how the clinic is configured, what opportunity it actually gets you to reach the audience, and some places that's easier, in other places it's harder, and that you need to look at this in a more nuanced way than to simply say 35 feet is always okay or 35 feet is never okay.
But Steve, you know it is the kind of issue that puts the ACLU at odds with people who would normally be your friends and supporters.
Well, maybe. I suspect that the position that we took in this case satisfied neither side. I think that the protesters...
Is that why you did it?
Well, you know, but the ACLU is frequently in that position, and it really is true that over
But I guess the question, I know I'm interrupting you, is why in a time when I don't think the ACLU has unlimited resources, so every decision you make is partly a resource decision and partly a hierarchical decision. How important is this decision? Why would the question of the precise amount of space and how that process is regulated be sufficiently important to involve a commitment from the ACLU?
Well, because I think again, because it involves the intersection of two rights we care deeply about, and because I think the broader question of whether the government can ever regulate speech, right, in order to promote another right, is an issue that is really critical to what the ACLU does and thinks about and cares about. And so it wasn't really approached as a resource issue, Raymond, but had it been approached as a resource issue, as the person who makes those resources calls, I would have said this is high on the list of things that are, justify our expenditure of resources. Moving
from abortion to contraception. Obamacare. Court's not finished with that, at least an aspect.
No, round two.
Tell us.
So 2 years ago, round one in the Supreme Court.
You're back to being a guide now. You can advocate.
Now I'm back to being a guide for a few minutes. So 2 years ago, the really big question was presented to the Supreme Court: did Congress exceed its authority when it adopted the Affordable Care Act, aka Obamacare, right? And the Supreme Court 5-4 upholds the statute, says Congress acted within its constitutional authority. Had the Obama administration lost that case, it would have been the end of Obamacare. It would have all been gone, right? But it held on by the skin of its teeth. So now a second issue has come to the Supreme Court, and this is the issue, that there have been a series of cases brought by business corporations, for-profit corporations, not the Catholic Church, not religiously affiliated nonprofit organizations, business corporations.
For-profit.
For-profit.
And non-church.
For-profit, non-church, and these are businesses that have thousands of employees who have come into court and said...
The most prominent being?
A large chain of hobby stores called Hobby Lobby. And they've come into court and said, look, we are a big corporation, but we are a privately held corporation. We're not a publicly traded corporation. It's my family that owns this business. And there is a requirement in Obamacare that I provide health care insurance to my employees, and that health care insurance, the Obama administration tells me, must include coverage for contraceptive care. I happen to believe that there are forms of contraception that amount to abortion and that violate my religious principles, and I think it is unconstitutional for the government to require me to offer an insurance plan to my employees that violate my own religious principles, right? And so they have sought a religious exemption to this requirement that applies to all businesses all across the country, that you have to provide comprehensive health insurance, including insurance for contraceptive care.
And this has reverberations of?
Well, Citizens United. But let me ask you, many of our viewers are not lawyers, although I think some lawyers would be curious about this. In some ways, a corporation is a person or treated as a person under the law, but not always. It isn't going to be drafted. It isn't when there's a draft. So when we're talking about
it's an intriguing thought.
That's right. So the question is, when it comes to the issue of religious belief, which seems to be attached to the notion of human beings in a corporal sense, how does that translate easily in terms of the law's regard for corporations as persons?
That's a big question. It's not the only big question in the case. It's a big question in the case. And there's been a lot of talk ever since Citizens United about our corporations persons under the Constitution. I think you're exactly right, Raymond. I don't think there's a single answer to that question. Citizens United says corporations have free speech rights, but corporations can't plead the Fifth Amendment. They have no privilege against self-incrimination, right? So I think you have to look at each constitutional provision separately. And it does seem to me, whatever you think about Citizens United, if you just accept for the moment that it's the law, there's still a difference between free speech rights and religious rights, because when corporations speak, in theory, the people who hear that speech benefit from it. That's our theory of free speech, right? You have a speaker and you have a listener, and the more information the listener can obtain, the better off the listener is. And so the corporation brings something to that public debate, right? That's not the way we think of religious rights. Religious rights are not about communication. They're not about dialogue. They're about, to put it as some people put it, do corporations have souls? And I think it is very, very hard, in fact, to argue that corporations have souls. And there are two arguments that are going on here. One is an argument that says, the corporation itself ought to be able to assert this religious right. The other one that says, look, however big we are, it's my business. It's my business, and so I am the corporation, and I have religious rights.
But you avail yourself of a corporate structure,
right.
So you are not the corporation.
And so the argument goes, but you can't have it both ways. The reason you incorporate is to separate yourself from the corporation, and now you can't claim that you are the same as the corporation. So there are really three issues in this case, and the court's going to have to deal with them.
Does this make predicting harder because you've got these triad of issues that are converging?
It makes predicting fun. So the first issue they have to decide is, can the corporate plaintiff raise a first religious claim at all, right? If the answer to that is no, end of case, right? If they can raise a religious claim, then the question is this requirement of Obamacare that you have to include contraceptive care in your insurance package, is that what the law calls a substantial burden on your religious rights, right? And so the plaintiffs come in and say, of course it is. I'm opposed to abortion. You're telling me I must provide insurance coverage for abortion for my employees. The argument on the other side is, but wait a second, the insurance coverage is part of your compensation package. Why is this any different than when you give salary to your employees? Your employee may use that salary to go out and buy contraception. That's not your responsibility. It's not your choice. It doesn't violate your religious beliefs. You've given compensation, and the employee has chosen how to operate that.
So where does this go?
So the second question is it a substantial burden? If the answer is no, end of case. If the court finds it is a substantial burden, then the government still has an argument to come in and say, but you know what? We have a sufficiently important reason on the other side to override your religious objection. Right?
So with 90 seconds to go and still wanting to get to Michigan and affirmative action, what do you predict?
I think it's going to be tough sledding in the Supreme Court.
Michigan?
Michigan. How did we come to Michigan? We thought race in education was resolved in Fisher a few months ago.
Right.
Why not?
Well, no battles are ever permanently won. and especially not when you're talking about race in America. And so here you've got to go back to 2003. In 2003, the Supreme Court said, in a case out of Michigan, right, that it was
higher education.
Higher education. It was constitutional for the University of Michigan to adopt an affirmative action plan in order to promote diversity among its student body. The response in Michigan to that decision was to amend the state constitution through a ballot initiative, was put to the voters, and the voters chose to amend the state constitution to prohibit the University of Michigan from adopting the kind of affirmative action plan that the Supreme Court said was permissible. Right. That then led to a second lawsuit, which is the one that is now before the Supreme Court. And the second lawsuit argues that the amendment to the state constitution to prohibit what the Supreme Court has allowed violates the United States Constitution and is itself a violation of equal protection.
Sounds pretty complex.
Well, you know, it's not. It is complex in some ways and simple in other ways. It politically,
so if it's simple in the next 10 seconds,
yeah.
How's it going to come out?
So here's the political. what makes it politically simple? We used to have affirmative action in Michigan, and now we don't. Right? That part is
and
that
where
part
are we
is
going
simple.
with it?
I think it's a really close call in the Supreme Court.
And Steve, even in a relatively low-key year, there is more to say than we have time for, as always. But we thank Steve Shapiro, National Legal Chief for the ACLU, for joining us yet again. And we thank you for watching. How do these high court cases strike you? Let us know at facebook.com/DueProcessTV.
And come back and see us next week and every week for more critical questions of law and justice. Till then, for Sandy, Associate Producer TANIA Ivanova, and all of us here at Due Process, I'm Raymond Brown.
Want even more insight on law and justice? Become a fan of Due Process on Facebook. Follow us on Twitter and watch us on demand on YouTube.